Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this live legal educational content, and today may be the day I earn your subscription. For today's coverage, we're continuing with United States of America versus Texas in relation to the heartbeat bill abortion ban that Texas passed in the form of SB 8. When we last left the action, we saw Texas's response to the motion to all this, and we thought, it was really good. Texas did a really good job, and so now the United States is going to reply to all this and see how that goes. So we're going to see how all that goes, and we're going to see how the U.S. argument goes. Where does it differ from the Texas argument? Where is it better than the Texas argument? What can we expect? Let's get started with this. It is every state's obligation to adhere to the United States Constitution as authoritatively constructed by the Supreme Court. Fair. The individual rights guaranteed by the Constitution cannot be nullified, their exercise deterred, and their promises rendered empty if only a state government is sufficiently brazen to enact a statute designed to evade judicial review. This is kind of a weak sauce argument. It might ultimately be right, but it's not a great start. There is processes. So in law, we have process and we have substance, right? So we have the way that things are done, and then we have what is done. And this is an argument over, well, they just chose a really complicated method that evades judicial review. And as Texas pointed out, that's not exactly correct. There is definitely ways to get judicial review. It's not necessarily preemptive, but this is not a great start. Texas's response to the United States motion for the injunction demonstrates why the injunction is necessary and in the public interest. On Texas's telling, a state is free to enact a law with both the purpose and effect of suppressing the exercise of federal constitutional rights. Whether or not it's the purpose or not is one thing, but the effect, sure. If a state imposes penalties that are sufficiently punitive to deter constitutionally protected conduct and also outsources enforcement to private parties, there's nothing federal courts can do to prevent wholesale violations of constitutional rights. That's not quite what Texas is arguing. You would just need an appropriate case or controversy. No individual plaintiffs can invoke the court's jurisdiction because of the 11th Amendment. And according to Texas, the United States cannot sue its own courts to ensure the supremacy of federal law because, Texas contends, the federal government is unaffected by the state's systematic suppression of federal constitutional rights and in any event has no authority to change it. So, yeah, this is all, no individual can sue Texas because of 11th Amendment sovereign immunity. You can't sue a state government in federal court unless the state says you can or the federal government has a specific statute. There is no state specific, there is no federal statute specifically. None has been cited, and Texas very much doesn't want to be sued in the federal courts. So yeah, under the 11th Amendment, no individual can sue them. Right. And then under the U.S. versus Texas, the idea is U.S. doesn't have a direct harm, so they can't sue them. Well, who can sue? Well, someone can offer a defense. So no one might be able to sue in the first instance. They might have to wait to be challenged, but that's already happened. Someone has been challenged. They've already done the come at me bro thing. So, it's not exactly it's evading complete judicial review. Texas makes virtually no effort to justify its intentional defiance of the Constitution on the merits, nor could it. If Texas wanted in good faith to ask the Supreme Court to overrule Roe and Casey, none of the unusual features of SB 8 would have been necessary. It could have simply banned all abortions after detect of a fatal heartbeat, acquiesced in an injunction in the lower courts, and asked the Supreme Court to reconsider its precedent. That would have worked too. But that's not what Texas did, and the reason is plain. SB 8's novel enforcement scheme is calculated to accomplish what no state should be able to do in our federal system: deter, suppress, and render moot rights guaranteed by the Constitution of the United States. Well, in the absence of any specific federal statute, Usually the idea is that the constitutional guarantees are not normally just thought of as self-executing. Normally you need something more specific or case law on it. So it's not quite right. The state does not dispute that SB 8 has virtually eliminated pre-viability abortions after 6 weeks of pregnancy. The state kind of disputes that. Moreover, their approach in Texas has taken need not be confined to abortion. We've raised that issue many, many times. If the mechanism works here, it would serve as a blueprint for suppression of nearly any other constitutional right guaranteed by the Supreme Court, but resented by state government. Yes, we've pointed that out many, many times. Many, many times have we noted that this technology can be used for suppression of all kinds of things. That's what makes the technology dangerous. SB 8 Texas enacted SB 8, and the state, through its agencies, officers, and agents, is accountable. Texas may have succeeded in suppressing federal constitutional rights in a way no individual person could easily challenge, but Texas enjoys no immunity from suit by the United States. If you can find a cause of action, that's true. The United States has authority to bring the suit, and the court has jurisdiction. As our opening brief explains, the United States brought this suit because SB 8 causes two forms of concrete harm. First, SB 8 undermines the supremacy of the federal Constitution by insulating a plainly unconstitutional law with an enforcement scheme designed to preclude judicial review. That's not really a harm to the federal government, though. Second, SB 8 interferes with federal government's operations in violation of preemption and intergovernmental immunity doctrines. That doesn't seem to be true, based on what Texas wrote. These concrete injuries plainly caused by SB 8 and redressable by injunction against enforcement support Article 3 jurisdiction. Texas appears not to question governmental authority to bring its preemption and intergovernmental immunity claims that are grounded in equity and the Supremacy Clause, and for good reason. The federal government has a well-established authority to sue the states directly, not their officials, to challenge state laws that offend doctrines of conflict preemption or intergovernmental immunity. Yeah, if there was a conflict with a statute or intergovernmental problem, then yeah, but there's not really on the federal level. Texas instead focuses its fire on the United States' request for relief as to its first injury, the harm of supremacy of the federal law. Texas's arguments are inconsistent with well-established rights to seek equitable relief where federal interests are implicated. This is not starting off super, super great. This is not super, super great. It reads a little bit like we have to have the ability to sue because it's really, really important, which is not the most persuasive legal argument ever. We surely have to have some kind of remedy to fix this egregious thing. And as the United States themselves would tell anyone trying to sue them, right, just because there is some harm the federal government has done or one of its agents doesn't mean you can necessarily sue them. So, yeah. Texas questions the government's authority to challenge SB 8 on the ground it violates the 14th Amendment in a manner designed to escape the supremacy of federal law. But the United States authority to challenge it flows from established Supreme Court precedent. In re Debs in 1895, the Supreme Court ruled that the government's authority to sue in equity to seek an injunction against the Pullman rail strike. The court explained that every government entrusted with the very terms of its being with powers and duties to be exercised and discharged for federal welfare has a right in its own courts for any proper assistance in the exercise of one and discharge of the other, and has no sufficient answer to appeal. That is no pecuniary interest in the matter. As I understand it, though, at the time, and for that matter still today, the federal government directly regulates the railroads. The railroads are controlled by the federal government. So, there is a difference there. Although it's not the province of the government to interfere in a mere matter of private controversy between individuals, whenever the wrongs contemplated are of such to affect the public at large, and in respect of matters to which the Constitution entrusted to the care of the nation, for example, interstate commerce, and concerning which the nation owes a duty to all citizens, securing them their common rights, then the mere fact that the government has no pecuniary interest, which means no monetary interest, in the controversy is not sufficient to exclude it, nor prevent it from taking measures to fully discharge. Again, it's a little bit different. Like the federal government might not be harmed monetarily, but the railroads are federal, much like the inland waterways. And so there is a jurisdiction that comes from kind of in rem, to be honest. It's attached to the property or attached to the easement, I guess, in the case of a railroad. But either way, it's federal government regulated. And that's not really true in the case of SB 8. There's nothing federal government regulated. I mean, about the clinics themselves. The clinics themselves are regulated as a matter of state law. Debs reflects the general rule that the United States may sue to protect its interests, and the right to sue is not limited to protection of statutory, as opposed to constitutional interests, and does not depend on the existence of statutory cause of action. So here they're trying to say, okay, we don't need a specific statutory cause of action. We can just sue nakedly under the Constitution. Okay. The Supreme Court has routinely recognized the government's authority to seek equitable relief against threat to various federal interests without an express statutory cause of action. In addition to allowing federal challenges to state laws that conflict with federal law or hinder federal operations, which is unclear that's happening, the court has allowed federal suits to protect the public from fraudulent patents, to protect tribes, and carry out the nation's treaties obligations. Well, the patent power is Article 1, Section 8, Clause 8. The ability to protect tribes is in the Constitution. The ability to conduct treaties is in the Constitution. There are explicit clauses for that. Debs recognized the United States has an equally cognizable interest at stake in a violation of federal law, including rights protected by the federal Constitution that affect the public at large, and are in respect of matters by which the Constitution are entrusted to the care of the nation, and concerning with the nation owes a duty to all citizens of securing them their own common rights. Texas does not meaningfully engage with this line of precedent, and its arguments as to why Debs is inapplicable disregards much of the language in the opinion. Texas's focus on Debs' recognition the United States could sue to protect its proprietary interests in the mail, so explicit constitutional authority for that, and statutory authority over rail commerce, their statutory authority. From this, Texas asserts the ability of the United States is limited to bringing suit only where it maintains a proprietary interest or where a statute affords the government particular powers. But the Debs court declined to place its decision upon that narrow proprietary interest ground, and the articulation of broader holdings discussed above in no way depends on the statute. The court's broad rationale was not dicta, as Texas suggests. It was the basis on which the court ruled. Nor is it unique to Debs. As noted above, the Supreme Court has recognized the government's authority to seek equitable relief without express statutory authority in other contexts. See, for example, Bell, conceiving of the essential right of the United States as one would allow the United States to vindicate its obligation to protect the public, in which American Bell included protecting the public from a monopoly of a patent which was procured by fraud. Since patents are issued by the United States government, they're issued by the U.S. government. So the fact that a patent was procured by fraud means that this thing was illegally obtained. This patent right, it was illegally obtained. So yeah, we're going to sue you for the fraud that caused this patent to mature. Seems pretty reasonable because it's a property interest. It's a property interest issued by the United States government. So we want to nullify this conveyance based on fraud. So we can sue for that. Seems pretty reasonable. There's not really a parallel situation here, though. Texas also frames the Debs case about whether the federal government has standing, not about whether it has a cause of action. But that understanding cannot be reconciled with the language of Debs itself, which speaks to the government's right to apply to its own courts for any proper assistance in power of duties, which sounds suspiciously like standing to my ear. And it would be inconsistent with the Supreme Court's subsequent observation. The United States is entitled to invoke the equity jurisdiction of its courts in order that it might properly discharge its duty, and it might obtain adequate relief sufficient to the nature of the case in accordance with the principles of equity. That all sounds to me like standing. The United States government has the ability to sue in law or equity when it has a legal or equitable interest in it. For example, the railroads, which the government controls, or the inland waterways, or the patent, which was issued by the United States government in the name of the government, or the mail, which also is protected by the United States Constitution, and the mail system, which is protected by federal statute, and so forth and so on. So it's not really 100% clear to me that those situations apply to this particular case. There's no federal statutes in play, really, when it comes to this issue. Texas recognized the United States suit in Debs did, in fact, involve an equitable cause of action. Contrary to Texas's understanding, though, the federal government's authority to bring suit in Debs did not turn on the existence of an equitable cause of action to abate a public nuisance. Okay. Instead, as described above, Debs recognized the federal government's more general authority to sue whenever the wrongs complained of are such that affect the public at large, and in respect by which the constitutions are instituted the care of the nation, like they are for the case of patents, and concerning what the nation owes its duty to all citizens of securing to them their common rights. I don't know. I feel like the United States is overreading Debs. This language sounds pretty good, but I also feel like they kind of are overreading it and over applying it. I mean, do we really have to go to Debs of 1895 and really figure out what the Supreme Court was really trying to say in all this? I guess maybe at some point we do. Maybe that'll be the next video. We'll discuss in re Debs, because both sides keep relying on it, and try to unpack what the Supreme Court was really trying to say in 1895. That could be fun. This is precisely a sort of suit that the United States can bring under the rationale of Debs. SB 8 offends the sovereign interest of the federal government in three ways. First, as discussed above, SB 8's procedural provisions have the effect of frustrating federal judicial review of the constitutionality of substantive provisions. So you can't just create procedure out of thin air. If they've come up with a procedural mechanism that works, then, go revise the procedural mechanisms. You can't just be like, we must have a procedural mechanism. I don't think that quite makes sense. Through Section 1983 in the Declaratory Judgment Act, Congress has provided individuals with the right to vindicate their constitutional rights and do so before those rights are infringed. Yes, but both 1983 and the Declaratory Judgment Act do not apply in this situation for reasons that we've covered before. Those statutes, which do grant authority, are not applicable in this situation because Texas, doing some clever lawyering, has worked around it. SB 8, however, is structured to limit or entirely eliminate the ability of pregnant persons to seek relief for deprivation of their constitutional right to a pre-viability abortion. It does so by foreclosing enforcement by executive officials of the state, thereby removing the traditional class of defendants that women may sue for equitable relief for violating her constitutional rights. Ooh, they're assuming their gender, right? Defendants that the women may sue for her. How they know it's a her? And creating onerous financial and litigation burdens to discourage healthcare providers from violating the statute, thereby limiting the extent to which SB 8 ever faces meaningful judicial scrutiny at all. Someone is actually taking it up right now as we speak. Indeed, it's the very presence of Texas's collusive scheme to prevent individuals from vindicating their rights that crucially distinguishes this case from those decided by Texas. Collusive scheme? I mean, I guess there's a collusion. The legislature is involved in a conspiracy to write laws. They're colluding. Sure. Okay. Yeah. All right. In none of these cases did the state deliberately legislate to prevent right holders from seeking judicial review for deprivation of their constitutional rights, which is kind of why Texas wrote it this way in the first place. If states can insulate their unconstitutional enactments from federal judicial review through mechanisms established by Congress, incidentally, Congress could establish new mechanisms, then states can effectively disregard their rights protected by the federal Constitution, thus violating the framers' dictate the Constitution shall be the supreme law of the land. As Texas has pointed out in its own response, the Texas courts are also bound to apply the United States Constitution. So it's not like you can't get any relief. And if the Texas courts decide on the basis of a federal issue, that would give you the basis to appeal to the federal courts after the Texas Supreme Court got done with it. So, you can go ask the U.S. Supreme Court when Texas makes a decision based on the federal law. SB 8 has significant effects on interstate commerce, hindering the flow of commerce in a manner that implicates federal concerns. Again, the situation seems a little bit inaccurate because the railroads were controlled by statute, by federal law. So there's no statute here that's really in play. As our opening brief explains, SB 8 burdens the interstate commercial activities of, for example, insurance companies that ordinarily reimburse plan holders for providing the abortions. They're still allowed to reimburse the abortions that don't take place. Banks that process payments for abortions, and manufacturers of drugs or devices used in the process of abortions. Well, if any of those people ever get sued, they can certainly seek relief. And as SB 8 has driven persons seeking abortion care to providers outside Texas, overburdening out-of-state clinics and creating backlogs for care. I don't know that I much care for the euphemism of care. It's like, this is just care. I'm not thrilled with that one. The Fifth Circuit has already recognized a state's regulation of abortion occurring within its borders may have a substantial effect on interstate commerce, as it concluded in upholding the Freedom of Access to Clinic Interests Act, which criminalizes various kinds of interference with abortion clinic access as an appropriate exercise of congressional authority under commerce. Yeah, Congress passed a statute, though. So the statute gave you authority. Correct. The court explained the interference with clinic access could have a substantial effect on the availability of abortion-related services in the national market. So the U.S. Supreme Court said that, yes, this was a valid regulation of commerce, which should surprise literally no one who is on this channel. Congress passed a law saying we get to regulate this because of interstate commerce, but they passed a law, though. Third, they interfere with federal programs and operations. These federal interests likewise support U.S. government's relief for equitable relief. For example, the Federal Bureau of Prisons and the Office of Refugee Resettlement each have obligations under federal law to facilitate access to abortions for individuals in their custody, but the agencies themselves do not administer the abortion care. Which they could, if they wanted to. There's the whole, what's it called? Is it the Dobbs Amendment? Or that prevents that from happening, but still. So as long as Texas maintains a legal regime that unconstitutionally limits most pre-viability abortion access, those agencies will be impeded in meeting their obligations. I don't know that makes sense. Texas is simply saying we're not providing it, which is not quite the same thing as impeding, as we've discussed. At a minimum, Texas decisions may require frequent transfers of persons in these agencies' custody out of the state whenever necessary to permit them access to abortion care that is unconstitutionally outlawed. I wouldn't know for sure, but I would think that they have to be transported between state lines for matters of practicality under the law anyway, but I wouldn't know for sure. Debs and his progeny fit within a broader body of precedent that recognizes the authority, the Hyde Amendment, thank you. Dobbs and his progeny fit within the broader body of precedent that recognizes the authority of the federal courts in appropriate circumstances like those presented here to entertain suits for equitable relief, even in the absence of an express or implied cause of action. Injunctive relief has long been recognized as proper means for preventing entities from acting unconstitutionally. There is a cause of action routinely exists for claims to enjoin official conduct that conflicts with the federal Constitution. The problem here is that there's no official conduct. Similarly, in certain circumstances, federal courts permit suits to enjoin plain violations of unambiguous laws where no other cause of action will provide a meaningful and adequate remedy for judicial review. But there are other methods of review. For example, the guy who said, "Come at me, bro." That's a method of review that seems appropriate. Federal courts also entertain suits by the U.S. government to ascertain its interests as the supreme sovereign. The same principles of equity that support those suits support the United States suits against Texas. Texas has interfered with sovereign interests of the United States by deliberately acting to prevent Texans from exercising their rights secured to them by the federal Constitution, while obstructing their ability to seek meaningful judicial review from that deprivation, using tools for doing so established by Congress. Because the tools established by Congress, right now we're talking about statutes again. When we say established by Congress, what that means is statute. That's what Congress does. They pass statutes. So yes, none of the statutes Congress passed allow a person to sue. Right. So that was the entire point. Congress can pass different statutes. Right? And Congress can pass different statutes. But none of the ones here grant authority. And the United States is left with, well, there must exist a right somewhere. Then, this does sort of raise the question of what is the point of 42 U.S.C. 1983, or what is the point of the Declaratory Judgment Act, right? If people must have a remedy, or the United States government must have a remedy, then why even bother passing a statute? Because you already had the power all at the same time. So what's the point of Congress passing statutes? Yeah. Texas invokes the cases where a court declined to imply causes of action under the Constitution does not undermine the point. Presumably, it undermines the point at least a little. Most critically, the Supreme Court cases cited involve alleged implied rights of action at law for damages, not for equitable relief. Okay. The Supreme Court has explained that expanding the implied Bivens cause of action for damages is disfavored. In contrast, an equitable suit under the Constitution is not lodged pursuant to a cause of action that's implied, but rather exists in a body of equitable doctrine, in the same way that cause for action for breach of contract is not implied from the contract, but exists in the body of common law. Okay. None of the Bivens cases that Texas cites calls into question the well-established body of equitable doctrine under which federal courts permit plaintiffs, including the United States, to sue to enjoin plainly unconstitutional action, which would never happen in a Bivens cause of action because you're suing a law enforcement. So before everyone gets all super excited about, oh, that means I can use this logic to sue the federal government to stop the unconstitutional violations, no, you can't. So don't get too excited. Texas further contends that by creating certain express statutory causes of action for the enforcement of constitutional and statutory rights, Congress impliedly precluded the type of equitable claims they are here to bring. It does raise the question of why Congress wrote those laws. Again, however, the equitable cause of action the United States is bringing is distinct from an implied cause of action for damages, which they're often more hesitant to recognize. So we're trying to separate the concepts of law and equity, which is always a good legal strategy, because they are different. And we're trying to say all this case law speaks to only legal, not equitable remedies. So, maybe. Even if this suit were properly thought of as being based on an implied cause of action, it would be improper to reason Congress's choice not to codify an express government cause of action for the enforcement as an expression of congressional intent that they're forbidden. I agree with that, right? I'm not a huge fan of that. I'm not a huge fan of Congress didn't pass a statute. They passed statutes. Right? They passed statutes dealing with this subject matter. That must mean there's no law outside that dealing with this subject matter. I'm not a huge fan of that, right? Because Congress passes laws, addressing a particular subject or a particular topic does not mean, unless of course Congress says otherwise, does not mean that Congress is intending to abolish other things that have been recognized by common law. So I agree with this. If you can find something in the common law that would allow you to do this, Congress passing statutes that allow you to do things should not be, unless the statutes themselves say otherwise, should not be read as nullifying or getting rid of the common law doctrines. The U.S. government's right about that. The Supreme Court has frequently cautioned that it's at best treacherous to find in congressional silence alone the adoption of a controlling rule of law. Preach. That's because, as a general matter, various equally tenable inferences may be drawn from inaction. Preach. Second, Congress did not consider the creation of an express governmental cause of action at the same time it created 1983's individual cause of action for vindication of rights. Congress enacted Section 1983 in the Ku Klux Klan Act of 1871. Not until 1957 did Congress first consider creating an express cause of action for the Attorney General to seek equitable relief for violations of constitutional rights, and subsequent proposals to that effect came into effect in 1959-1963, which if the Attorney General implicitly has causes of action. So while it is disfavored to say a statute that doesn't exist controls, it does raise the question of why does Congress bother passing the laws at all? Because if the Attorney General has an implied equitable cause of action, then what's the purpose for everything, right? That seems to be the U.S. government's argument, for everything. If the Attorney General has an implied cause of action for everything, then what's the point of Congress in 1957, 1959, and 1963 looking to what the Attorney General might have the power to do? Why bother? This is also a well-established principle of law when I'm saying that, by the way. We assume that Congress doesn't write things for the hell of it. We assume that everything Congress writes has meaning. The federal courts, by case law, strive to give meaning and effect to every single pronouncement of Congress. Right? We attempt to avoid saying Congress wrote something that doesn't mean anything. So the problem with the U.S. government's argument, as I'm understanding it, is that the U.S. government is trying to say the U.S. Attorney General has an implied cause of action to redress any constitutional harm. That seems to be what they're saying. That also seems to imply that in 1959 and 1963, the federal Congress has passed laws that don't mean anything because they're already implied. But that doesn't really make sense. We assume that Congress meant something by it. Why would they write it if it didn't mean anything? Why bother? So the idea that it must mean the idea the Attorney General has implied power to do some other things, yes. That they have the implied power to do all the other things seems contra to why the statute would be passed. Does any of that make any sense? It is well established that negative implications raised by disparate provisions are strongest in those instances in which relevant statutory provisions are considered simultaneously. That's fair. So if Congress is considering multiple things at the same time and didn't adopt something, that might have more of an implication. That's fair. Congress's choice to enact 1983 in 1871 and not to enact a governmental cause of action until nearly a century later thus cannot be understood, Texas suggests, to reflect a detailed remedial scheme. But why did they pass the law in the 20th century? Texas additionally argues that the United States lacks standing to pursue its interest. That's a no-go. The United States has standing. I think that's a non-starter. The United States has standing. Whether or not they have a cause of action is a whole nother problem. So I mean, to show standing, technically speaking, they also have to show harm, which is part of the standing. So technically speaking, you could say they don't have standing because they don't have harm. So if you view standing that way, then right. But the fundamental principle, they have the right to seek redress in the courts if they have a cause of action. They've got that for sure. In 1906, Congress enacted a statute broadening the class of Native Americans entitled to participate in an allotment of lands and funds, initially authorized by a 1902 statute. Yes? After disputes over the constitutionality of the 1906 statute arose, Congress enacted a statute in 1907 that specifically named 4 individuals as authorized to bring suits. As the court recognized, the object and purpose of the cause of action was wholly comprised in the determination of constitutional validity of certain acts of Congress, and the attorney for the private litigants, if successful, were to be paid out of funds of the Treasury of the United States belonging to the beneficiaries. The Supreme Court held that these manufactured suits did not provide a judiciable cause for controversy. While the United States was a defendant to the action, the court explained, it had no interest that was adverse to the claimants because it was not itself a potential claimant of the property or funds. So the United States here was an irrelevancy. Rather, the court observed the whole purpose of the law was to determine the constitutional validity of the reapportionment statute in a suit not arising between a reapportionment, which would have given you standing. Unlike that case, however, there's plainly adversary between the United States and the state of Texas. Is there, though? As an initial matter, this action bears none of the hallmarks of a collusive suit that were at issue in Muskrat. Didn't you say earlier it was collusive, or did I misread you? The teaching of Muskrat is that Congress must not be allowed to approach closely a request for judicial advice, even as contemplated legislation, by the simple device of conferring jurisdiction over a specific suit to be brought by individual names as plaintiffs seeking to challenge. So yeah, no advisory opinions are allowed, even if you create a statute that basically says in so many words, you can get an advisory opinion. Congress can't do that. Moreover, unlike Muskrat, where the United States has no concrete interest to defend, which I'm not sure that logic really holds. In fact, it kind of holds better in Muskrat than it does here, because the United States Constitution gives authority to the federal government to manage Indian lands and Indian properties. There's an explicit clause about that in the Constitution. So the federal government's ability to manage the lands is a direct federal concern. Exclusive federal concern, I might notice. All issues dealing with Native Americans go through the federal government. So if even in that situation, the Supreme Court ruled that these tribal people didn't have authority for reallotment. Reallotment is a fancy name of saying redividing the property, by the way, in case you're wondering what that means, right? So they wanted to take property, and they want to take it from some people and give it to some other people. Okay, that's reallotment. Congress passes a law saying, hey, this Indian tribal land, which we said is this, now we say is this. It's a different division of land or different people, right? Different people. So it's changing the property rights. That's reallotment. So Congress over here passes a law saying we are changing who the property is owned by statute. And they give authority to named individuals to bring suit. And even there, even where everything is federal, even where all the claims are federal, even there where all the issues dealing with Native Americans are federal, the U.S. Supreme Court ruled that the federal government didn't have enough standing or enough cause of action. Take your pick between either one. Because there's nothing at issue for them other than the statute's validity. But they can't get an advisory opinion. Right? If Congress wants to pass a reallotment act and the property has changed hands, then those people can sue. And the United States can offer an amicus on one side or the other. And it can even maybe move to intervene in some way. But it can't do that. So if it can't do that in a situation where federal interest is exclusive and paramount, then why would it be able to do so in this situation, which is not that? So this case seems to, in my view, really hurt the United States' position. Like, even where all the issues are exclusively federal, you still can't bring this before the courts unless you can show some harm to the United States. And our law might be invalid is not enough harm, because that's getting an advisory opinion. So if you can't get it in all the things are federal, how are you getting it where pretty much all the things are state? It seems to counsel against this result. SB 8 is not a law that permits private parties to seek redress for private harms through the court. It is a law that articulates an alleged public harm, namely provision of constitutionally protected abortion after cardiac activity is detected. In a bid to outflank judicial review, the state has deputized private individuals by offering $10,000 bounties. But the maneuver does not obscure the fundamental point. The state incentives private parties to prosecute the state's interest, not their own. I agree with that fundamentally. It is a state interest. I think that, it's a state interest. I'm on board with that. But you can't sue any state official because there's no state officials to enjoin. And there's no real direct harm to the United States that's really been quantified, except in the rights of its citizens, but that's not enough. See, for example, the Native American case we just talked about just now. Although, I might want to be cautious there. Because in 1906, I don't think Native Americans were considered citizens of the United States yet. I don't think that happened until the 1920s. So when I just said just now about the citizens for the Native Americans, I don't think Native Americans had citizenship in 1906. So you'll have to modify accordingly on that one. The United States seeks an injunction that would stay any state court proceeding initiated under SB 8. Texas contends that this court is powerless to order that relief, and it cannot require the state to cease implementing and enforcing an unconstitutional statutory scheme. That proposal is remarkable. The state of Texas enacted the law. The statute is conceitedly intended to affect state policy about whether abortion should occur after cardiac activity is detectable. The statute is enforced by individuals cloaked in state authority, and enforcement actions are prosecuted with the assistance of state judicial and administrative apparatus. It's not clear, incidentally, that there's any administrative apparatus. That doesn't seem to be true under SB 8. The judicial apparatus, yes. Administrative apparatus doesn't seem to be correct, as far as I know. And yet the state now contends it has nothing to do with ongoing injuries that SB 8 inflicts. That suggestion, if accepted, would fundamentally undermine the rule of law. Maybe, but maybe Congress needs to pass a new statute. And as everyone in the chat, including the U.S. government, has noted, this might be used to infringe other constitutional rights. For example, the Second Amendment. Now, I would be remiss if I didn't point out that under the U.S. government's logic here, they would be able to bring suits for Second Amendment rights being denied by states because they'd be protecting a federal interest. So anytime that federal government wants to start filing suits against states for infringing the Second Amendment, in the same way they're filing suits for people, not having the right to abortion, anytime they want to do that, you let me know. Doctrinally, Texas is wrong because the state is an appropriate defendant for the suit and can be subject to an injunction by the court. I'm not 100% sure it can. Who are you enjoining? Exactly. You can't enjoin the executive branch because none of them are involved. You can't enjoin the legislative branch, and you can't enjoin the judicial branch as matters of policy. So you're enjoining all the private citizens who don't have notice. I wonder if they'll get to that issue at any point. Indeed, Texas does not dispute that enforcement requires some component of the state to act, and so an injunction against the state itself would suffice to redress. But you're getting an injunction against the judicial branch, which is contrary to ex parte Young. Texas, however, argues the United States has not proposed a specific relief and any injunction must identify the individuals, employees, and agents who would be bound. But Texas lacks authority for the specificity it demands. Unlike the context of injunctions against the federal government in the Administrative Procedures Act, there's no need for this court to cabin injunctions within the contours of a particular waiver of sovereign immunity. Maybe. But you still have to give notice, I think. There's no bar to an injunction that runs against the state. Indeed, the state surely knows who it employs who will be responsible for staying any proceeding under SB 8. A more fundamental problem is the Texas Attorney General can't give an order to the judicial branch. The Texas Attorney General is an executive official. The Texas Attorney General is the chief law enforcement officer of the state. That's what the Attorney General is. They're the chief law enforcement officer. So as the chief law enforcement officer, they can give orders to the entire executive branch, because that's what the executive branch does: enforce the law in all of its manifestations. So the Attorney General can give an order, to the entire executive branch about, you can't do this anymore because I'm the Attorney General. But, the Attorney General can't give an order to the legislature. He can't give an order to the judicial branch. There are different branches of government. You have a bit of a problem. Yeah. Pro Me US asks, what does yelling mean? You used way too many capital letters. That's what it means. Don't use capital letters. It's shouting. Capital letters is shouting. Caps is yelling. Please don't yell. Yes, you cannot caps 3 words. You're correct. Indeed, the state... Okay, we read that. Stepping back, Texas' contention is it's not proper subject to court order relief is central to effects to evade requirements of the federal constitution. Over 50 years ago, the Supreme Court made clear in school desegregation cases the context that constitutional rights cannot be nullified by hostile state actors. All right, let's consider this. Whoever by virtue of public positions, and you immediately have a problem, under state government denies or takes away the equal protection of the laws, violates the constitutional inhibition, and he acts in the name and for the state, is clothed with state's power, his act is that of the state. This must be so, and the Constitution has no meaning. These prohibitions of the 14th Amendment extend to all actions of the state, denying equal protection of the law, whatever the agency of the state taking action or whatever guise it's taken. Yeah, but the problem here is you're trying to find a way the state is denying equal protection. And it's not. I mean, everyone gets the closest is the fee-shifting statute, which might be a violation of equal protection. So that might be a problem. But other than that, there is due process. You can seek redress in the courts. I don't think this situation is quite right. If Texas' argument is about the scope of relief accepted, then all state needs to do to nullify a constitutional right is to pair a sufficiently punitive statutory scheme with a provision deregulating enforcement of that scheme. Well, kind of, but yeah. Under that approach, the state could enact laws imposing ruinous financial penalties on any person who performs an interracial marriage, sells firearms, which again, anytime you want to enforce Second Amendment rights, you let me know, federal government, performs a Catholic mass, or criticizes elected officials. They've got a point. Texas offers no principled basis for distinguishing such schemes. And that's true. Texas can't offer a principled argument. Right? The statute may not be able to just be copy-pasted. It might be a little bit more complex than that. But fundamentally, at its core, can you take the logic, or can you take the technology at its core and repurpose it? The answer is yes. Is there any principled reason that you can't do that? No, there's not. If it applies here, it applies everywhere. I've never said anything contrary to that. Because, yeah, if it applies here, it applies everywhere. You have to follow the logic all the way through. And I've pointed out, as the federal government just did just now, why that might be very, very bad. right? So, yeah, there are problems here. But the fact it's very bad does not necessarily in and of itself mean a decision has to go one way or another. We have to consider the law. And that's what we aim to do here on Uncivil Law. We try to consider the law. So whether it's bad or whether it's good is a judgment for you as you consider what this would be. Whether or not it's legal is what we're doing here, right? Pro-Me, the U.S. says, like the precedent of removing the filibuster. This is such a hyper-technical point, but we'll do it anyway. And I apologize to Pro-Me, the U.S. in advance. Very hyper-technically, the precedent of removing the filibuster is not a precedent. Because the legislature is not bound by its prior actions like the courts are. So it's not really precedent, it's just history. So, yeah, that's a hyper-technical point. I'm sorry. I probably shouldn't have said anything. The Senate and the House of Representatives are under absolutely no obligation of any variety to do anything that they ever did before and can contradict themselves at any time because, yeah. That relief should entail an injunction against the state staying all proceedings under SB 8. An automatic stay of proceedings brought under SB 8 would upend the apparatuses of deterrence at the center of the constitutional design. No greater specificity is required, but even if it were, Texas is acting through three groups of individuals who can properly be enjoined. Private individuals, but you might have to give them notice. State court judges and clerks, ex parte Young seems to say no, and other administrative personnel and enforcing, which don't seem to exist. Relief any one against these groups would see. Yeah, so the third group doesn't seem to exist. The second group is barred by ex parte Young, and the first group is a problem because the private individuals haven't been given notice and an opportunity to be heard. Yeah. Texas disregards the most straightforward relief that the United States requested, an injunction staying all court proceedings. Ex parte Young says you can't do that. Congress has expressly confirmed through the Anti-Injunction Act that a stay of court proceedings can be an appropriate remedy even if states put before private parties. Yeah. Given the Anti-Injunction Act's restrictions do not apply to suits brought by the United States, by definition, such relief is available here. Okay, this means I have to pull the Anti-Injunction Act, so I can find out if what the U.S. government is saying makes sense. So please bear with me as I pull the Anti-Injunction Act to find out if this makes sense. Hold on. Okay. 28 U.S.C. 2283, stay of state court proceedings. A court of the United States may not grant an injunction to stay proceedings in a state court except as expressly authorized by an act of Congress or where necessary in aid of its jurisdiction or to protect or effectuate its judgments. Okay, so let me unpack that for you and let me tell you why the United States is just wrong, okay? The United States argument is wrong, okay? So what it says is a court of the United States may not grant an injunction to state proceedings in a state court. Okay, that's your baseline. You can't do it. Except as authorized by an act of Congress, which doesn't exist in this situation. There is no act of Congress. Where necessary in aid of its jurisdiction. Okay, so that would be the situation where if a state court was doing something that the federal courts had jurisdiction over. So, for example, just to bring up the patent thing, because why not? Patents are exclusively federal jurisdiction on validity. So if you try to sue in a state court for a patent issue, and somehow the state court fails to notice that this is an exclusively federal issue, which it is, because the patent law is very clear on this, you can get an injunction for that. Because, again, it's a jurisdictional issue. Only the U.S. federal courts have jurisdiction. So or like a dispute between states. So I don't know if Texas is trying to sue Georgia in even Georgia's courts. So Texas decides to sue Georgia, and even Georgia's courts, they can't do that because that has to be heard by the U.S. Supreme Court. So you can do it if it's necessary to get jurisdiction, which isn't true here, or to protect or effectuate its judgments, which isn't true here because you don't have any judgment that's on point. Basically, you're trying to protect or effectuate its judgment. You're trying to cram Roe and Casey into that, which is no, you can't do that. So the U.S. government is just wrong here on this Anti-Injunction Act. So the U.S. government can bite me. Ricardo Ospinilla says, my problem with the law is there's no limiting principle. That law, if it's upheld, could ban any right. You are correct, sir. Right? There is no limiting principle. You are correct. That is a problem. It is a reason not to like the law. It is a reason not to like it. That's perfectly valid. That if this is successful, it can be applied anywhere. Yeah. Now, unfortunately, as we all well know, that in and of itself is not a legal argument. So, if I had my druthers, and this is the first time I've ever expressed an opinion about SB 8, because I wanted to try to remain neutral the whole time. But if I had my druthers, I'd strike it down too. I know. But I've tried not to express an opinion this whole time because, it's not relevant to the legal analysis, right? So I have to analyze the law, and I have to analyze what it says, and it seems like U.S. government is floundering here. That's just my best legal opinion. So we press on. It's definitely a reason for legislative action. That's definitely true. It's definitely a reason for Congress to get off their ass. That is for sure true. Here, consistent with Congress's recognition that injunctions in state courts and a state court are appropriate. Congress's recognition? Bullshit. The court could provide that very same relief and or directed to the state. The Congress did not. The Congress. Wow, that's just wrong. Congress recognizes injunctions. Injunctions are equitable. That's no. Texas first contends this court cannot extend its injunction to private individuals seeking to enforce because the court has not provided those individuals with the opportunity to be heard. I thought this was a pretty good argument from Texas. Seemed right to me. Now, I'm totally open to being convinced I was wrong or that Texas was saying some crap. I am 100% ready to say Texas was saying some crap, and you can do this. So the question is, can the U.S. government convince me? Please try harder. But yeah, can you convince me that you can do this without giving notice? Okay. There's no requirement that a court, before enjoining an entity and expecting its injunction be complied with, which each of those entity agents and other affiliates must first provide every individual conceivable, subject to injunction with notice and opportunity to be heard regarding the scope of the injunction. Well, normally, yeah, that's normally true. Like if you're suing like Microsoft, for example, just to pick a company at random, if you enjoin the company, then then the company has authority over its employees, right? So it's like, yeah, but the Attorney General, do they have authority over the citizens of the of the state of Texas in the exercise of this law? I mean, maybe, but they're not really his agents because he doesn't control them. The thing is not quite right. I'm not saying that you're not. Please get better. If that were the rule, the Supreme Court could not have upheld an injunction against the state of Arizona governing the conduct of its state and local enforcement officers without first providing all those individual law enforcement officers notice. No. Because I will assume without reading it, they sued the Attorney General. And the Attorney General is the chief law enforcement officer of the state. Every law enforcement entity within the state of Arizona ultimately works for the Attorney General. That's how that works. So if the Attorney General loses, he can give a command to the entire state apparatus because that's what he does with his time. And circulate a memo. But I'm not really sure about that one here. And Also, just on a purely argumentative ground, this argument is weak. This is an appeal to credulity. A lot of this argument is really an appeal to credulity, to be quite honest. The legal rationale is a little thin, in my view. They cite a few cases, but it's thin. It's thin. It's mostly an appeal to credulity. This can't possibly be true. It's incredulous. It's an appeal to credulity. It's a one big logical fallacy. It's not great. If this were true, the world would come to an end. Which might be true, but, not the greatest legal argument. They're not really citing a lot of precedent. They're definitely not citing any statutes from Congress. It's not going great. Ricardo Ospina gives me another $5. Allowing this would be like adding a notwithstanding clause to the American Constitution, which would be very bad. I'm not disagreeing with you, man. I'm not disagreeing with you. It could be fixed by Congress, though. So strictly speaking, it isn't adding a clause to the Constitution, because if it were, Congress couldn't fix it, and they can fix it. So, again, hyper-technical, but anyway. Texas is conflating whether an injunction can be issued with whether an individual can be held in contempt for violating the injunction. Okay, that might work. Holding a non-party with notice cannot be held in contempt until shown to be in concert or participation. Okay. In any event, binding precedent confirms that notice requirements do not limit the appropriate scope of the injunction. If anything, the counsel of requiring Texas to advertise the unavailability of relief. So, they're trying to say there's a difference between giving an injunction that impacts everyone versus a potential contempt for not filing the injunction. So if you're a named party and you don't file the injunction, you're going to have a bad time. If you're a non-named party. So actually the U.S. government might be right here. It's not particularly well argued in my view, but an injunction in one case would inform other cases. So if you prevented a company from doing something, then like the other companies in the same posture wouldn't be able to either, even though because we work on a precedential system. So even though it might impact all the companies in some sense, you might be able to enjoin the conduct anyway. It's just that if they're a non-party, you can't get contempt until you show something more specific, but you can enjoin the conduct. So maybe. Yeah, the legislature can definitely fix this if they want to, it seems to me. Aside from the erroneous procedural objection, Texas offers little to support its claim that individuals following enforcement actions are not probably subject to injunction from this court. Texas asserts injunctions cannot bind non-parties. As Texas acknowledges, however, the rule does not apply to agents of an enjoined party, or to non-parties who are in active concert or participation with the enjoined party. You might be able to squeeze that through. Active concert or participation, because it's a public cause of action, you might be able to squeeze that through. Texas later acknowledges the rule was intended to prevent defendants from nullifying a decree by carrying out acts through aiders and abettors. Consistent with the principles, courts have long extended injunctions to actions of non-parties. The fact that the petitioner was not a party to suit, nor served with process for subpoena, nor had notice of application, nor was served by officers, are immaterial so long as it was made to appear that he had notice of the issuing of the injunction. Because the court has inherent power to protect its ability to render a binding judgment, injunctions may extend to third parties in a position to upset the court's adjudication. That's actually a pretty good argument. And it's better because they're arguing the inherent power of the court. So they're arguing it from the inherent power of the court to do stuff. The court has inherent rights to do things even if statute doesn't allow it. Which is true. Courts have inherent power to do things. And so the court, in exercise of its power to do things, can enjoin non-parties if it would frustrate the injunction, even if they didn't get notice. That's actually pretty good. Did I say persuasive injunction? What did I say? Did I say persuasive? I don't know what I meant. I don't think it said persuasive. There's no such thing as a persuasive objection. Or injunction, sorry. Oh, persuasive in the sense it could inform other decisions. Okay, fine, great. Yeah, persuasive in the sense it could inform other decisions. Yes. So, yeah, because we work on a precedential system. So, yeah, it's a little wrong to say persuasive injunction, but the injunction itself is persuasive is better. Because we work on a precedential system. So every decision from a court is persuasive to other judgments. So that makes sense. Okay. So it's persuasive in that sense. Here, individuals filing suit under SB 8 never necessarily further Texas's scheme to undermine federal rights guaranteed by the Constitution. These individuals have no power to file the suit, nor any basis for suing persons who become defendants. This court therefore may enjoin the private individuals who Texas has deputized to implement the state's scheme. And this will argue it's becoming a trend in law. That's right. That's fair. The courts may enjoin private parties Texas has deputized to implement state scheme. That might be true. So the United States argument about why they don't have to give notice to literally all the people makes way more sense. Well, I won't go so far as to say way more sense. It makes more sense than Texas because these people are acting as agents of the state. I think you're there because these are not private causes of action. This is not a harm that is befalling any of the people who would be suing. It is a harm that would be befalling the state of Texas. So yeah, every person is a private attorney general. And therefore they're a state actor. So you can enjoin them. Makes logical sense. Works for me. Yeah, makes logical sense. They still have problems on the cause of action thing. So they still have problems somewhere else. But if you didn't have that problem, could you get an injunction? Yeah. But you still have the problem of showing a cause of action. So, which is kind of thin and appeal to credulity. So they can get an injunction if they have a cause of action, but I'm not sold. Any person who files suit seeking to enforce SB 8 is in active concert and participation with Texas' goals of prohibiting abortions, which brings them within the scope of the court's authority. That makes sense. As the Fifth Circuit has observed, another case that strongly excited community passions, the scheme Texas has adopted here means judicial relief is particularly vulnerable to disruption by undefinable classes of persons who are neither parties nor acting. In that sort of scenario, courts may exercise broad and flexible remedial powers to meet the situation and protect the court's judgment. Yeah, that makes sense. Texas also contends that individuals filing suit under SB 8 cannot be acting in concert with the state based on Texas versus Department of Labor. But the Fifth Circuit's decision in that case depended on the statutory scheme at issue. The statute created distinct roles for the United States and private individuals. So the United States could sue. People could sue. Such that litigation by a government agency would not preclude a private party from vindicating a wrong. So, yeah, the United States had the ability to sue and private people had the ability to sue, but the people who were suing were not vindicating the United States' interest. They were vindicating their own interests that was separate and apart. As contrast, SB 8 can only be understood as vindicating public interest. I think that's got to be correct. There's no separate governmental cause of action. Individuals are authorized to pursue enforcement against anyone, regardless of whether they've been personally affected or not, and success on the claim requires both statutory damages unconnected to personal injury and injunction for benefit of the public. Yeah, so this is a state cause of action. The harm that is befalling is Texas. It is not any of these people suing. They have suffered no harm. So the only way for this to make any logical sense is that they're private attorney generals and vindicating the state's interest, which incidentally is not inherently illegal. California does it. They have a similar thing. Theirs is much more legal, but the idea of private, and also there's some in federal law too. There's one for mismarking of patents. Private individuals can bring that. And also, at least similarly, whistleblower protections. That allows individuals to get compensation. So there's examples where private individuals can bring public causes of action that are independent from the government. So sure, this just isn't one of them. Texas also disputes a separate basis which individuals could be subject to an injunction. They are state actors sufficient to render them agents. The state of Texas enacted SB 8, vested private individuals public enforcement authority, and dictated the terms of that enforcement authority. And the state retains the legal right and ability to withdraw or otherwise modify the terms of its enforcement. Regardless of the distance Texas now seeks to place between itself and its appointed cadre of citizens, that does not change the nature of the principal-agent relationship. I think the U.S. government has this one. A person may be an agent, although a principal lacks the right to control a full range of agent activities, how the agent uses their time, or agents exercise their professional judgment. A principal's failure to exercise right of control does not eliminate it. Fair. Totally fair. Moreover, the primary state cause in which Texas relies supports availability of relief. We have constantly held that private parties' joint participation with state officials in seizure of disputed property is sufficient to characterize that as part of a state actor. Private parties jointly engaged with states in prohibited actions are under color of law. I buy it. To act under color of law does not require that the accused be an officer of the state. It's enough that they be a willing participant in joint activity with state agents. Well, that's a little bit overstated. It's not quite that simple, but yeah, I think you're there here. When viewed as state action, acting in concert with the state of Texas or some combination of both, the bottom line result is the same. The rules extend plainly to individuals who affirmatively choose to cloak themselves in state authority. Finally, to the extent there was doubt, the court could independently issue an injunction pursuant to the All Writs Act. Ooh. Going with the All Writs Act is dangerous. Let me give you a little bit of history of the All Writs Act. Okay, in the old days, there used to be lots and lots of different writs, lots of writs. I don't even remember what they are. There used to be lots of. Why would I remember? Because it's ancient legal history, right? So we got a couple of them still floating around. We got the writ of mandamus. We got a writ of certiorari. We got a couple other ones in there, I think, too. But basically, there used to be a whole bunch of these other writs that existed. And Congress passed this thing called the All Writs Act, which basically says, we're abolishing all the writs. We're abolishing all the writs because these are all kind of stupid, which, to be fair, they are. Except for these legacy ones that we just talked about just now. But then it has this wonderful clause in there as a catch-all, which says that the courts can issue any writ they want to exercise their judgment. So they abolished all the writs and then brought them all back in the same cause of action. So there's no longer a writ of, I can't even give you an example because I don't remember. So there's no longer a writ of, but if the courts want to, they can issue the writ of. They just can't call it that because, okay. So the All Writs Act basically says, in so many words, the courts can issue any writ that will help them do their job. It's pretty expansive. For that reason, going to the All Writs Act to find authority is questionable at best. This was the way the federal government was trying to get Apple to insert backdoor encryption into its software. They were trying to say it's the All Writs Act. And I'm like, no. I don't think the All Writs Act, for all of its power of issue all the things goes that far. So, yeah. The powers conferred by the Act extends under appropriate circumstances to persons who are not parties to the original actions or engage in wrongdoing, are in a position to frustrate the implementation of a court order or proper administration. Injunctions may be issued against non-parties under the All Writs Act. We believe the All Writs Act requires no more than persons enjoined have minimum contacts that are constitutionally required under due process. Here, then, there can be no dispute that groups of persons subject to injunction have sufficient minimum contacts because they have affirmatively availed themselves of the court system. That is fair, right? So that is fair. Like, do these people have sufficient minimum contacts? And the answer is yes. There has to be, because all these people would be filing suit in Texas courts. And we already know from our discussions before that if you're the plaintiff, you're there, right? So any random person may not have sufficient minimum contacts, but the moment they file a suit in Texas, they do. For at least the purposes of that suit. So yeah, so that's 100% right. Relief under all writs is appropriate because it would be directed at conduct which, left unchecked, would have practical effect of diminishing the courts. An injunction against Texas may also be extended to judges and clerks. I am dubious. An injunction against all the people, sure, that makes logical sense. An injunction against the courts? I don't know, man. Danger, Will Robinson, danger. An injunction against the state of Texas would properly run to state judicial officials, including judges and clerks. Such an injunction would be appropriate here, given the role state courts play in the enforcement scheme. It's a threat of suits under the statute that deters providers from offering services. And so an injunction that requires state judges and clerks to say, decline to docket, which how would a state clerk know that? Seriously. Or otherwise decline to maintain a suit is appropriate. Texas offers two principal responses. The United States lacks standing to sue individual judges and clerks, and the court lacks power to issue an injunction that would run to those. Texas's first argument is Article 3 does not permit suits against state court judges or clerks, is a non sequitur. No state court judge or clerk is a defendant here, only Texas itself. Oh, that's such a lame argument. That's such a lame argument because you just got through saying just now. Oh my God. And the United States plainly has standing to sue the state for reasons above. Thus, renders irrelevant states' arguments about court's jurisdiction issue an argument that runs the state judiciary. Ex parte young, ma'am. Ex parte young. The state court might be a governmental apparatus, but no. Texas tries to create distance from its own judiciary by contending they're not within the scope of the rule and not be covered by any injunction issued against Texas, which is true, right? It fails to explain how judicial officials are anything other than officers, agents, servants, or employees of the state. Well, yes, but it's the judicial branch. Ex parte young. Perhaps recognizing Texas's judicial officers are indeed part of the state of Texas, which sure. The state tries to reframe the standing inquiry by suggesting there's no adversity between the United States and individual judges. But the state cites no authority for the proposition that standing should focus on anything other than adversary between the two parties to the case. Had Texas made SB 8 enforceable by the Texas Attorney General's office, there would be no requirement that landlords be personally adverse to parties to be bound by injunction. To that end, Texas' reliance on case or controversy in the recent motions decision misses the mark because that decision, together with relevant portions, and Texas' attempted reframing all focus narrowly on adversities between private parties and individual judges and clerks who were defendants in that action. Because adversity between the United States and Texas is clear, standing is no party. No bar. No. Nor has any other party to the issue of injunction that would run to state judges and clerks. Please mention ex parte young at some point. Texas contends that Muskrat is such an obstacle, and the case stands for the proposition that injunction that's binding on Texas cannot bind the state courts. But the case suggests nothing of the sort. The Muskrat court contends the advisory opinions have no bearing. Yeah, with respect to that question, Pullman makes clear federal courts can issue injunctions that bind state judicial officials. Judicial immunity is not a bar to prospective injunctions for relief of a judicial officer acting in their judicial capacity. For state courts? Do I seriously have to pull a U.S. Supreme Court case to figure out whether or not they're saying something that makes sense. Hold on. Let's see. Okay, hold on. Judicial immunity is not a bar to prospective injunctive relief against a judicial officer. Common law principles of immunity were incorporated in the judicial system. The history of judicial immunity is consistent with common law. Judicial immunity is no bar to awards of attorney's fees. Okay, I need the actual case, not the syllabus. Thank you. After respondents were arrested for non-jailable misdemeanors, petitioner, a magistrate in Virginia, imposed bail. And when they were unable to meet bail, petitioner committed them to jail. They brought action under 42 U.S.C. 1983 claiming the practice of imposing bail on persons arrested for non-jailable offenses and of incarcerating those persons that they could not meet bail was unconstitutional. Yeah. The court agreed and enjoined the practice. Determining judicial immunity did not extend to judicial relief under 1983, but the courts aren't being sued here under 1983, so that doesn't really make sense. Plus, there's a specific federal law in play where there's not one here. So I'm still going back to Ex parte Young. Pressing on. If there were any doubt the court has the issue to injunction that runs the state courts, the reasoning in Pullman removes it. Texas acknowledges Pullman permits injunctions against state court judges, but the state claims it has no relevance here on the theory Pullman decision of judicial immunity was limited to injunctions issued pursuant to 1983, which does seem to be correct. That characterization cannot be squared with the court's reasoning. Indeed, the court went to great lengths to detail the common law rejection of a rule of judicial immunity from prospective relief. Yeah, but then went to 1983 as the basis for relief. And decisions from at least 7 circuits support the determination there's no bar to issuing prospective relief against state judges. Because the court found neither concern contained such restriction, held prospective relief against state judges were available. The remaining authority on which Texas relies do not alter the availability. State relies on dicta from Ex parte Young, but the suggestion and injunction that runs the state judiciary would be a violation of the whole scheme of government cannot be squared with the holding in Pullman or myriad other cases that have issued an injunction. I'm dubious. The state's discussion of writs of mandamus and prohibition run into the same problem. The Pullman court expressly discussed the issuance of writs of prohibition and mandamus by judges of the King's Bench en route to holding that federal courts do have authority to enjoin state judges. I am not sold on this analysis. Texas suggests the exercise of state authority would call into question the neutrality of state judges who are bound to follow the Constitution, but the suggestion ignores the reality. It's a threat of suit that's chilled abortion providers throughout the state. I'm not. They might be right. I'm just not sold on this analysis. I'm not sold. I'm not sold. The United States federal government is accurately citing these cases and their process for their language. I am doubtful. I have pressed X to doubt. I'm not. I don't think. Yeah, it doesn't ring true. It might be correct, but it just. I'm not sure. It seems wrong. So short of pulling every case they cite and figuring out what it says, and I did pull Pullman, which seems to be going under 1983 for a specific rationale, which you don't have here. So there's that, but, yeah. Texas does not dispute the court can enjoin personnel involved in execution of judgments and other administrative roles. Fine. They show a likelihood of success, Violates the 14th Amendment. Texas contends the Supreme Court has applied the undue burden test in similar contexts and should be done so here. But neither of these cases concern an outright ban, which it isn't, well, on a broad swath of pre-viability abortion. It's settled that laws that limit certain methods of abortion or certain requirements of those seeking abortions are distinct under Casey. But they said it doesn't apply in the case of an undue burden. So I'm not... Texas is issued that its unconstitutional abortion ban is not a ban. It's academic because law cannot survive even cursory review under undue burden test. It bans most pre-viability abortions and uses the threat of monetary penalties to chill providers from using lawful procedures, which is a better argument for the abortion providers, incidentally. And once they have an actual controversy like they do, they're going to get there. The undue burden test in Casey announces the standard states must comply with when enacting abortion regulations. Casey, the state may not impose an undue burden on women's ability to choose. Disclaiming its own obligation, Texas argued it meets the undue burden test because it permits a limited set of third parties to argue, after having been sued, that they will impose an undue burden. The undue burden is front-loaded, an obstacle in the path of women seeking abortion. Threat of liability has led to providers stopping to offer abortion services and therefore prevent persons from accessing abortions. State's undue burden defense, that is to say the fact the courts considering it might find statute to be unconstitutional, provides no avenue for relief to persons who cannot find a provider willing to assume the risk and costs. SB 8 denies those persons any option to assert their rights in court. And even where the undue burden defense can be raised by others, Texas restricts the defense in manners inconsistent with Casey. In other words, Texas contends that SB 8 meets Casey's undue burden standard because Texas may assert something called an undue burden, but Texas does not in theory or practice preserve this right. I'm not sure about that. Yeah. All right, so I am only 38 pages, but to be honest, I'm tired. So we may do a part 2, we may not. But overall, I found the U.S. government's argument a little weak. Their argument on the standing, their argument on an action is a little thin and a little bit appeal to credulity. Their arguments on other aspects, though, make a lot of sense. Their arguments why they can enjoin all the private people make sense. Their arguments about why they can enjoin the state courts, I'm definitely not sold. I'm not sold that they're quoting the law correctly. And yeah, so overall it's okay, but I still think Texas has a better end of it, all things considered. So we may do a part 2. If we do a part 2, it's not going to be for a while, because I won't be at my computer to do recordings for a while. But we may pick it up later, but we'll see. If you've enjoyed this stream, I hope that you will give it a like. If you're not already subscribed, you can become a subscriber. And for 99 cents, you too can become an Uncivilian and help the channel grow. It's late. I'm tired. Until later, my friends, I hope all is well. Cheers and goodbye.